everybody back from lunch. Our next topic is responding to an office action, and our presenter for this topic is Michael Huygens. He has an undergraduate degree from Rutgers, Scarlet Knights, and he has a lot.
1 in 15 my year. They were 1 in 15 when I was there. I know, now the Big Ten.
His law degree is from Seton Hall Law School. Pirates! Arr!
Could be.
He's registered to practice law in New York and New Jersey, and he's had his own practice since 2007, which specializes in patent, trademark, and copyright law. So please give a warm welcome to Michael, and we will see about responding to office actions.
Okay. Hi, I'm Michael Huygens, that is how I pronounce my name. She got it correct. There's apparently a big debate about that. The debate I had with the NAPP board was how much time I was going to get to give this talk. There's a much longer version of this presentation on my website that I give yearly to Lawline as a CLE provider. So when I was talking to them, they first had to get it down to 20 minutes. I said, I can't do that. So they emailed me back the next day. It's like, okay, fine, we can give you 10 minutes. Like, I don't understand. I give a 2-hour presentation. Now you want it in 10 minutes. So they emailed me back again and said, okay, fine, 15 minutes. I said, okay, 20, 10, 15, 45 minutes, I can do that. So that's what we're going to do here. I have a 45-minute presentation where I'm not going to crack any patent attorney jokes just because I don't know any. If anyone knows any patent attorney jokes, feel free to shout them out. Otherwise, let's keep questions sort of limited because I don't have too much time. Is that a patent attorney joke? No? Okay. I thought every time I give a talk, I'm hoping for one. But okay, anyway. First, in responding to an office action, basically, now everything that David just taught you, if you didn't get it right, too bad, it's too late. Once it's set, you can't add any new matter. You can sort of finagle things. You try and do that in Europe, Germany especially. If you don't have the exact wording in, you're done. You have to take the exact wording from the summary or from somewhere where it's more important to have in the summary in Europe. But in any case, you now work with what you got. And on top of that, you need to remember what you did 2, 3, or sometimes 5 years ago. And you look back at your writing from 3 years ago where you were, and you have to figure out, what did I mean and how do I clean this up? It's more fun when you're cleaning up someone else's language, there's someone else to blame. But then on the flip side, I'm going to go through an example, first of a crazy office action. So this was a claim in an application. Let's see if they figure out the laser pointer. Laser pointer. The device of claim 1, wherein, whatever, you don't need the details, the device is coupled to a neutral wire. So simple electrical claim, we couple something to a wire. The office action says, see Heart 5B. So presumably he means figure 5B. You have to figure that out sometimes, but there's no further explanation. So I looked at Heart figure 5B, and this is what I saw. A real office action. I'm giving you a real-world example of what you see at the patent office sometimes. Now, examination sometimes is better than this. Let's say it's usually better than this. But, I get more laughs on this, neutral wire. Can anyone find the neutral wire? Just to read this in case you can't see it. This is amplitude on the y-axis. This is time on the x-axis. Where is the neutral wire? Couldn't tell you. Anyway, so the telephone interview, examiner has to get his SPE, which is patent attorney lingo, patent office lingo for supervising primary examiner on the phone, which is good because then there's someone else you can discuss. The problem is when the examiner who does this is the supervisor, and then you have bigger problems. That happens too. And anyway, he refuses to discuss this claim. He's discussing the dependent claim, discussing around the issue, and it was worse than this. Every single rejection. Claim 1, it was rejected due to figure 5B. Claim 2, 5C. Claim 3, 5E, and so forth. It went sequentially. No relation whatsoever. After 20 minutes, the examiner says, we don't have enough time. What do you want me to do? I'm given 6, 7, 8 hours maybe to go back and forth and examine this application and try and figure out what this talks about. And meanwhile, you're dealing with somebody who probably could be making 3 to 5 times more if he could get a job in the private sector or if he was a law firm or engineer, whatever it is. Many of these guys are coming from outside of the country. Now it's less so. More so, you get people who are native English speakers, but you have to deal with this, and you have to deal with it. These are people working for the government that are given a certain amount of time, and depending on the politics going on in the patent office, they're given less or more time or whatever it is. They may be very good at what they do, they may not be. It's all over the place, and it depends on art unit as well. We'll get into that. There's certain art units, just you hit certain art units, expect to appeal, plan to appeal. In certain art units, they're not allowing a thing through. Do a lot of software and business method patents. It's just brutal right now. If anyone can tell me a way to draft this is a serious question. If anyone knows after the Alice case the proper way to draft a claim for a pure software application, please tell me, because I'm stuck right now. It used to be the law changed every 10 years and every 5 years and every 3 years, sort of State Street or Bank Street, 3 years, 2 years. The singularity is near. It's like to the point where it changes faster than, for those of you who have read, I forgot his name, Kurzweil's books. He says technology is increasing so fast that eventually things that we create with machines will catch up to the mind, will augment our mind, and it will just increase at an infinite pace because it gets there. That's how I feel with business method patents. Singularity in terms of claim language is near. It's just every 6 months now the language changes. So you need to look at your application from 5 years ago, deal with these rejections, and figure out what to do with it. So what you do is the first thing that you see is something like this. And what I'm going to try and do for you is I've broken this down into a step-by-step method. And basically, when you get an office action, you're going to get pages and pages of telling you what's going on there. Pages of rejections. It could be 20, 30 pages. It could cite 6 references. And the problem is you see this whole big thing before you, and you need to figure out what to do with it. So, and it's just overwhelming to see this whole thing. So my method that I'm going to go through, I call it the LOTA, or LOTA if you want to pronounce it, method. It's going to go through 4 steps. It's just basically a 4-step iterative method that you're going to repeat over and over until you get the big picture. It's basically taking away that emotional thing, and we're going to go through step by step each line of the claim and so forth until you digest it, and then you put it back together, and you're going to see the whole picture again. So first, look at this. So this, mail date, first thing you're going to want to do, you're going to want to docket your dates, case file and so forth, examiner. And this is the first sheet that you're going to see. This sheet sometimes is helpful, sometimes not. Sometimes it has correct information. Sometimes it doesn't. So here, claims 1 through 20 are pending. 1 through 10, 15 through 20 are withdrawn from consideration. 11 through 14 are rejected. Everything else, this examiner restricted. I happen to get them all back together in rejoinder for a fun talk on restriction requirements, where they say it's multiple inventions because you describe 2 sometimes just slight variations, or the method and device. They'll split it into 2 applications, so it's less work. You file a division and so forth. That's in my full talk. I'm not going to go into that today. But in any case, first thing you do is docket the deadlines. Most important thing is do not miss a deadline. I'm not an expert on malpractice. Thankfully, I haven't had to deal with that. But what I've heard is a huge malpractice issue for attorneys is not necessarily doing a bad job. It's missing a deadline. You miss a deadline, it goes abandoned. Usually you can fix anything at the patent office. There's one thing that's required to fix anything. Just yell it out. What do you do to fix a problem at the patent office? Pay a fee, money. That's usually a problem. If you miss a 6-month deadline, you pay more fees. You revive the application. After 2 years, you can revive. So that was all the way back in my patent bar course. I remember the instructor there was saying, if you weren't sure what the question was on the patent bar exam, choose. You can narrow it down. Choose one of the answers is to pay a fee. So what I do is I use a system called Docket Track. Use a free plug for Docket Track. I love it because they just started a patent system. Bruce Young is going to talk about docketing systems more tomorrow, I believe. But what they will do is they will actually, you set it up to copy not only you, but you copy the Docket Track system on the USPTO electronic dockets, and they will send them an email. And in the morning when I come into my office, when I see 52 emails from foreign clients, among them are one from Docket Track that says we'll put in the date of the rejection, list of references, and it will docket the date. So like I got an office action May 8th, 2014. It'll automatically docketed 3-month and 6-month date in my docketing system and sends me reminders. This isn't responding to an office action per se, but this is really important to docket these dates and make sure to hit it up by the deadline. So 3 months is a regular deadline. I send my invoices with an electronic system, automatically sends the client my reminder at 30 days, your invoice is overdue. This is more about practice. I don't do work without, it depends on the client. Most of my clients, I don't do work without getting paid. I send them the bill, they pay it, then I do the work. Don't have to spend your time billing because I want to spend my time responding to office actions. And then 3 months is the regular deadline. At 5 months, if you still haven't heard from them and they're not telling you, you really start bugging them, make phone calls, docket all that stuff that you've called them and so forth. Then after that, one of the first things I do, this is new for this presentation, is there's a patent attorney out in California who may be here for all I know. He runs a website called examinerwatchdog.com. This website is great because you know what you're up against. It will tell you, if you look up you look up your examiner, this is Benjamin Leno, good guy. I say that because he allowed my patent to go through some bias. Is the one that I'm going to talk about today, he had like a 64% allowance rate. And it'll tell you how many abandoned, how many appeals, and get a sense of it. And you can also look up by art unit. So for example, Yagdeta Retta, this is all public data. I don't know if she's here attending the conference. If she is, I'll be gone tomorrow. So Yagdeta Retta at Art Unit 3622, she has a 2% allowance rate. If you hit up that examiner, insert your expletive. 3 out of 150 published cases allowed, and they're probably due to appeals anyway. So you set up your claims to appeal. Save yourself the trouble of spending too much time. You know, one response, wait for the final rejection, make sure your claims are perfect, no 112 issues, stuff like that, because you're probably going to have to appeal. Now, on the other hand, I'm not going to read this out loud, but that's the examiner's name in Art Unit 2835. I got to include humor in this somewhere. Patent stuff isn't necessarily whatever. But Art Unit 2835, he has a 92.3% allowance rate, 671 out of 746. Most of the art unit is like this. You can search by art unit, you can get a feel for that art unit. You get into 3622, they're all 0 to 10%. I mean, there's guys, I've heard stories. I think Diane, once wrote this on the NAPP practice group, that you saw an examiner that on his door had a 0% allowance rate and was proud of it. I think that was you. I don't know if it was you or somebody wrote that on there. So, you know what you're up against. You can strategize along that way. You may prefer not to look and just deal with it first. I'm too curious, I look. But and then before we get started, make sure the reference is valid. Check the earliest filing dates. It used to be when you could swear behind a reference, you cared more because oftentimes rejections were 102E, which was less than a year ago with the published patent application, and you might actually have an earlier filing date or be swear behind. Won't go into that too much because you really can't swear behind on anything you're filing today, and I assume most people who are here are for today filed applications. Since the law changed, we're now a first-to-file system. Review the examiner's search history. This is something no one ever taught me, but I just sort of figured out that if you look at after the office action, you can see how much they searched. You can see what classes and subclasses they searched. They give a restriction, and they say restricted to class 705, and they search 379 anyway, and your other one was in 379, you say, hey, your restriction made no sense. I've never gotten anywhere with that argument, but you can't tell an examiner the restriction requirement made no sense. It doesn't work. Anyway, and you'll see, you get a sense of where did they search, how much searching did they do, how close are these references, did they understand what they were looking at? For example, David gave the example of fingerprint or fingerprint, help me out here, fingerprint something versus the other fingerprint. Images, fingerprint, or fingerprint image are totally two different things. You get a sense of where they searched and how much. And the reality is most first office actions are poor because they don't take the time to read it. Oftentimes they read the claims. Oftentimes they don't understand it. Whatever it is. Or they're just plain old saving it for the second office action when they cite the better rejection. Because many times people don't respond to first office action, so whatever happens. And the examiners are not typically, unless they're new, like within their first year, typically no one is giving them oversight on the first office action. They get oversight when they allow a case, and now someone else looks at it, now they can get into trouble. So first office action is like 90% rejection. First patent attorney that I got trained from, he told me, if you draft a claim and it's allowed at the first office action, your claim was terrible. You should have drafted broader. You could have gotten more. You get more and get the rejection. So, and then you have to argue it. So sometimes I explain it to clients like this. It's like you have health insurance. It's kind of like that. You put the claim through the first time, it's rejected. You now have to go call, wait on hold, and fight for it until you get the claim through. The wording fits exactly. Okay. So they've gotten a little better. I've noticed healthcare has gotten a little better since Obamacare has came in, and now they're like, no, we have to try and do a little better before the government completely takes over our job. But I'm near Washington, so I won't speak too much about that. So, okay, check for 101, 102. So these are the different types of rejections. So just get a sense of what's going on. A 101 rejection, as David said, you didn't see them very often a couple years ago. Now, anytime you're in business method software area, you see them whether it's deserved or not. 102 is it's new. Is it cited in one rejection? 103 is it obvious over a combination of references. 112, structural type rejections. You didn't use a semicolon. You said A instead of said or whatever. So when you receive the first office action, you can either send it to the client without comment or you can review it first. In general, I like to give my clients some information. I tell them, here's a few sentences. Here's what's going on in the office action in plain English. If it's 10 pages of 112 rejections, which I'll admit, I feel like Alcoholics Anonymous meeting, but I'll admit I've gotten plenty of 112 rejections, which is you didn't draft the claims properly or the examiner. Sometimes the examiner doesn't understand it. I don't care, whatever. That can be cleaned up, usually. This is really bad. Enablement, that's a pretty bigger problem. But you can clean it up. I'll say, skip to page 8. Page 8, here's the substantive thing. They cited Goldstein in view of Huang, and they combined them and said that it discloses your invention, or whatever it is. So most clients will want to see some information, some direction, but it also depends on the technology. I have a client who is she's a professor at a university in New Jersey, and she's a foremost expert in boronizing titanium in the world. I have a third patent about to issue for her third filed, second issued, for boronizing titanium. I don't get it so much, to be honest. But so I show her this. These are the references. I say, you tell me what that says. Is that boronizing titanium? I mean, I'm giving a facetious example. It's more specific than that. But I send the client the art, and remember, the goal is to respond in the best manner to get the broadest claims allowed. So whatever tools work for you in order to get the broadest claims allowed, that's what you do. Whether it's seek help from other attorneys, NAPP practice list is great. The email list is great. People answer your questions and so forth. I'm a frequent commenter on there. Sometimes I use it to rant when I'm too upset with something examiners are doing. You can just ignore those emails and skip to the substantive ones. That's totally fine. I won't know who's really reading, who's responding, who's just lurking anyway. But anyway, the goal in mind is to get the broadest claims available. So if it means consulting with your client, great. A good number of my clients haven't a clue about this stuff. They have a broad general idea, and I'm writing the technology. I am, inventing the in-depth versions of it and putting all the computer processors and network nodes and so forth. So, and they don't care. They don't want to look at it. Just get me a patent. They're running their business. Patent is a side thing, whatever. They want patents, and you just get it for them. All right, so now I'm going to step into the actual rejections. So the goal is we're going to do this in manageable pieces. First thing I recommend is don't read the examiner's argument first. Who cares what the examiner says? They're going to confuse you. Unless you know yourself, I can quote you various self-help books, Shakespeare, whatever it is. You need to know yourself before you know other people. You need to understand yourself in your own arguments. And on top of that, you're not going to remember what you wrote or what it's about. And sometimes a simple case you will, but if it's a complex case, you really need to understand it. So first thing is refresh your memory. Review your patent application and your claims. And then after you understand it, I actually go through an exercise, and especially have my associates go through an exercise where I tell them, first thing you do is you write first paragraph, what is your application? And give me a citation. This will eventually be used in the office action, so it's not just an empty exercise. Give me a paragraph on what your application is about. Don't just take the abstract, that's cheating. You can take a sentence from the abstract, take a sentence here, cite it. Everything is citations. Everything cite paragraph numbers because the examiner can actually look. And I'll show examples of this later on in the presentation. And after that, do the prior art. Give me a paragraph on each of the pieces of prior art. I haven't touched the examiner's argument. I don't want to know what they are, usually. If it's really stupid, it's really simple, you might not want to do this, but this is in a substantive case. Again, use whatever method works for you, but I'm giving you a method of breaking this down very systematic. And if you have a paragraph of the prior art with citations, every sentence have a citation. It discloses a light bulb changer, which first step is it grabs the light bulb and unscrews it, and then it brings in an arm, puts in the other one. Each sentence, paragraph 72, paragraph 75, and so forth. And now that they've written this paragraph, now we're going to use this later to describe what our invention is, and we haven't muddied the water, and what the prior art cites, and we haven't muddied the water with the examiner's arguments. So we basically say, my invention discloses features A and B. This prior art reference discloses B and C. This one discloses B and D. None of them disclose A and C together. And I basically, that's the substance of the response. And this should take about an hour to do. New associates, it takes about 8 to 20 hours to do. And then they get down to 10, and then they get down to 5, and then they leave. Anyway, so here is an example. A spherical ball with internal transponder freely movable about an interior space. Wait, did I skip it? I'm sorry, I hit the thing. So, with transponder freely movable about an interior space where the transponder falls to the gravitational bottom. So this is paragraph 39. So this is an example of the points that I put in the paragraph on one of my applications. So the reason I'm using this one is it's going to be visual, as you will soon see. There it is. There is this transponder. This is basically an RFID transmitter in a bingo ball. He is doing RFID bingo. That's all this patent is. So the whole idea, it's actually a pretty cool idea. I mean, it's simple enough, and it's patented if anyone wants to license it. Is the basic idea is when you're playing the bingo game and you have the bingo balls, that you can you have the balls come out. It automatically reads the balls as they come out and puts them on the screen, and you can have it called B52. Here, I'll point for the camera. You can have it called B52, and it will actually tell you what's going on. So that's what it is, and it's a resin ball with this thing in the middle. So what he's got is it's freely movable in the interior space. And side note, just interesting fact, is at least in the state of New Jersey where I live, bingo is ridiculously regulated, and he almost decided not to go through with this because the balls have to be equally weighted. So a thing inside moving around, we had to make sure we could make the transponder circular and equally weighted so you wouldn't have a problem with the regulations for bingo. No idea how regulated bingo games are. Anyway, prevents the ball from getting lost by rolling away as the transponder is constantly working against the centrifugal motion of the ball. So this was stuff that I put in the application when I drafted it, is how am I going to sell this to the patent office? I'm going to disagree with David here for a second. I love background in the invention. The reason I like it is because it gives you a chance to sell your invention to the patent office. It gives you a few paragraphs to tell you what is the prior art, what is the problem. But you don't want to give it away. You don't want to lead too obviously to what you're getting into. But you might talk about in general the problems. But there is the caveat, which David would argue the other point is, don't bother because you're risking hurting yourself. So the way to get around that is put that in detailed description. You talk about now the problem is transponder is constantly working against the centrifugal motion of the ball, meaning it won't let the ball roll away because you have this other ball inside rolling away. So I ended up, you don't know when you're drafting the claim, I didn't know that was going to be useful. You put the kitchen sink in the patent application. You draft everything as broadly as possible. You don't know how you're going to amend what prior arts can be cited. However good your prior art search is, there's a reference that you get a Japanese examiner that gets a reference from Japan you never would have found, which has happened to me. And then it's like, what am I going to do with that? And then you got to start reworking the whole thing, and you got to find what's in your application. If it wasn't in your application, you're done. So that's important to keep everything as much as possible in the application. So further, as recited in paragraph 39, this is important implications for efficient reading of data on the transponder, as the reader is placed immediately below or next to known position of the transponder and the ball's resting position. In other words, your ball is rolling. This is actually the prior art one, but the transponder would fall to the bottom, and your reader is right below as the ball passes through, so it's right next to it. And so I said, look at this extra great utility of the fact that the thing rolls around inside. Now, the reason this became important is because I actually went back and I modified my first paragraph after I looked at the closest prior art. US 2006 blah 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 to Ito is directed towards balls that are made of translucent resin with an RFID tag. This was a major problem. Here is a ball with a RFID tag right in the middle. And these things are being sold by some Chinese company for bingo balls for 10 cents a piece or whatever they're charging. And you can buy them if you go on the internet and look for them. And you could probably get around my client's patent too by selling these balls because of how we had the limit in view of these. But it is what it is. You get the broadest claims you can get. And at the end of the day, your goal is what? No. You would think that. That's only secondary. Your goal is to make the client happy. If you have a happy client and you fail and you can't get the patent through, you're fine. Client is happy, you make money, client's happy, it's fine. Now, it's true. One of the secondary characteristics of making a client happy is an issued patent. I mean, that's like plus 40 on this happiness scale for client. It's true. It's a big factor. But let's not confuse that with the primary, 103 rejection, the primary and the secondary considerations. For me, getting a patent is a secondary consideration. It's one that makes me feel good. Usually makes my client feel good. But client happy, that's the primary goal here. Broadest claim, even better. He goes take the litigation, sues someone, get billions of dollars, even better. But it's all because you're working for the client. All right, anyway. So reference shows RFID tag 3 fixed in a plane passing through the center of ball 2. So this is actually how I described it. Look, because the examiner cited figure 3, and this thing is fixed in the plane, I have no idea, is this a solid ball, is this not? No reference has been located, and this is actually the wording that I used in the response to the office action. No reference has been located stating whether the ball is hollow or solid, or that the RFID tag is anywhere other than the fixed position shown in figure 3. In other words, if you look at that, the examiner cited this and rejected, and he cited, I'm getting ahead of myself a little, and he cited this, look, ball with RFID tag. It's good rejection, That's something, I would probably have cited on someone too if I was the examiner. But there's no disclosure of what it's doing, and I see the thing floating here, so maybe this is a solid ball. And in fact, I looked at found this company, and I found where they were selling it, and it looks to me that they're selling solid balls with the RFID tag solidly in there. So I think the client's patent would even be defensible in court over that. So now we've reviewed our claims, we've looked at the prior art ourselves, we've picked out the differences in the claimed features. And, And we're now clear on where we stand. Only now we look at the arguments in the office action. So basically, this is what I do. Now that we understood what we're doing, we go through the LODA method, or this is my method. Basically, I just heard somebody was telling me when he first went to a firm, and my experience going to a firm was similar. Here's an office action. Come up with the arguments and respond to it. No one teaches you how to do it. So copy and paste each limitation. I actually would take each limitation and each claim, I put it on the top of the page. An RFID ball, okay, I'm not going to argue that. That's there. Next limitation. Freely movable. Okay, now I'm going to see what does the examiner say for that, for example. So now, once I copy the limitation, I copy and paste the rejection. In Adobe PDF Reader, it's very easy to just select it and copy and paste. They give you image PDFs because don't expect that to be updated for the next 20, 30 years. But right now, they still give you stuff in image, so you can't just copy and paste the text. Then you take that and put it next to it. Now, you copy and paste the cited text. So L, limitation, O, office action, T, the cited text. Now you've got it all side by side, and now your argument. Now you've basically broken it down to little bite-sized pieces. Does the text match the limitation? So you're just going to repeat this until you cycle through each and every limitation of a claim, go on to the next claim. Now, if you see something like a ball, and he cites something for a ball, you might want to just skip that and do the ones that matter. But each limitation, you take the limitation, okay, and what you do is when you take the limitation, you write under it, what's been cited, what's the office action say, what's been cited. Oftentimes that will be enough. You look at what the office action says, you look at what the prior art reference says, they don't match. Or the examiners often do keyword searches. It'll be the same keyword, but a totally different meaning. So don't ever get hung up on what the examiner says. You need to check systematically, is what they're saying true? So line by line. And this will also help you find if there's a claim limitation, they didn't cite it, they didn't talk about it at all, point that out. No reference has been cited whatsoever for this limitation. And I basically view everything as a 102, meaning everything, each and every feature has to be shown in the claim. 103 is in multiple pieces of prior art put together, and you can argue it's not obvious to put them together, but frankly, I grew up, I'm the youngest, I had two older brothers, and to me, arguing with the examiner about that's not obvious, and they turn back and say, yes, it is. I'm like the younger brother. They had bigger fists. I didn't win those arguments. So they work for the government. They don't need you for anything. They say it's obvious. You lost. It's very hard to overcome those rejections. Unless you're teaching away from the prior art, those type of things. But in general, I'd find each and every limitation. If it's found there, great. If not, now that's where we argue. And and only if, like my associates come to me, they say, oh, we need to amend this claim. Okay, show me each limitation. Limitations A through F. Show me each limitation of the prior art. Only if each limitation is found do I then amend the prior art. If not, I argue. There's cases where you just want to get the case allowed and you can work with the examiner. Then you might want to amend, and it also depends on your client. David spoke about this as well. When my client was a large telecom company that I was doing overflow work for, they argued everything. If you could argue it, they argued it. But if your client is a small guy who doesn't want to spend another penny on this, and he's like, what do you mean I got to pay more for responsive office action? You're an attorney. Why don't you get this through right away? That type of client, it's like, well, you're not going to get the broadest claims possible, but okay, I'll amend the claims. I'll get this through. You'll be happy because why? What's the end goal? Happy client. Thank you. Happy client. Okay, so okay, let's move on. Okay, so here is carrying out the method. So, limitation, generally spherical encasement with a hollow interior. So that was my limitation. That was actually my original claim language too, as I recall. Spherical encasement with a hollow interior, the office action. Each ball comprises, so first limitation, second office action, the L, the O. Each ball comprises a spherical encasement with a hollow interior, see figure 3. Now, that's all he said, and the reason I'm using this example because it's very visual, I can point it out in 2 seconds to you. Here is the text. I actually went and copied this. And I did this even though at first I didn't see it. At first, you have ups and downs during prosecution. There's days when you get 3 notices of allowances, and there's days when you get 112 and 101 rejections, and you're like, I got to do something else. This was one of those 101, 112 days. And I copied this anyway. I put it on, and there I'm looking at this, and I'm like, okay, spherical encasement with hollow interior. Wait a minute, that's all you cited. Who says that's hollow? You say that's hollow. I don't know that's hollow. The burden is on the office action. They need to show, quote, each and every limitation of a claim. If they don't show it, it doesn't count. So the argument is figure 3 is not enough to show hollow. That's basically the crux of my argument. I wrote it out in more flowery language, more legal language, and so forth. But that was basically the argument. Next one. This was a limitation of a near-field communication reader below an exit tube. So this was, the ball went down past the exit tube. The reader, the RFID reader, for those who don't know what RFID is, it's Easy Pass. Easy Pass is RFID. Do they have Easy Pass in California, or is that just I'm sorry. It's an East Coast thing. They got it as far as Illinois, so Chicago people should understand. Basically, you drive through, and there's a transponder in your car. Fast Pass. Sorry. Anyway, you guys are pretty well awake for 11 a.m., so, okay. Anyway, the Fast Pass, Easy Pass, and basically it reads the thing by radio signal and a transponder to it and so forth. So near-field communication reader below an exit tube. The ball selector also comprises a near-field communication reader, antenna 48, which is below an exit tube, blah, blah, blah. Okay, now, there is no antenna 48. So I couldn't find antenna 48 in the paragraph that he was citing. It turned out he was off, 67 to 68. Now, I could have put in a response, doesn't cite that in paragraph 67. Would have been a waste of an argument. Technically, you're right, but the best argument is the one that makes you novel over the prior art, not the one that wins you the argument. Your idea is not to win the battle unless you're collecting client fees, because then they'll come back and cite it properly with the new rejection. Finally, you file a continuation. The more ethical practice would be to look, and the better job practice would be to say, okay, you don't mean that, you mean something else in paragraph 68. You might have the totally wrong number. Here it is. Here's the antenna, and so forth. So what do? I find it. Antenna 48 is disposed between rotating disc 45, 46. Here it is. That's not below. So and that's in figure 8, whatever. It's the wrong thing. There was guide duct 47. He might have meant that. Point being, the guide duct 47, even if it was down there, was not an antenna. You can't say that's the transmitter and so forth. So, conclusion. Limitation, you got a reader below an exit tube. Office action, it was bogus, but we looked further and we found a, quote, proper citation of the antenna. Text shows antenna as a coil around the ball, not under the exit tube. So, oh, kidding. That whole thing was the antenna. So, but I said it was under the exit tube. You might want to limit to only under the exit tube. This is where when you're drafting your application, sometimes I use the word only. Sometimes I use the word consisting, comprising. I say this could consist, comprise, or only be, blah, blah, blah. And just you draft as broad as possible so that way you can amend to that language. Some examiners, depending on the art unit, depending on practice area, if it's more mechanical areas, they'll let you fudge it and get away with things in the pictures. I once had pacifier weeding device that they're getting smaller and smaller. The nub was getting smaller and smaller. I used the word circumference, and the examiner said, well, circumference in the dictionary might not mean around the circle. It could be used around anything. I didn't know that. I'd never seen circumference used that way. So if you use the word circumference, define you mean circumference around a circle. But in any case, to get around the prior art rejection, I couldn't rely on my word circumference. I had no definition, and he could use the dictionary lacking my definition. So this is actually the word he came up with. He said, call it a bulbous tip. I didn't have bulbous tip in it anywhere, but he said, that's fine. It's a bulbous tip. We insert it into the specification. He said, not consider that new matter. That depends on your examiner. Some of them are very friendly, very helpful. Others aren't going to let you get away with anything. So the reader, the office action, no, it's not there. Text, antenna coiled around a ball, but not near the exit tube. Argument, the prior art citation does not show a reader below the exit tube because the reader is actually around the ball path and above the exit tube. So that was my argument. I actually didn't even need to rely on it because claim 1, or claim 11 got allowed, and so forth. All right, and then you do that for each and every limitation. 102, 103, find each limitation in each claim. If you want to then go and argue it's not obvious after you found each limitation and see if it's there or not, that's up to you. I generally, as a practical matter, I look at it, I think about it, but I rarely argue that it's not obvious to combine. I don't find those arguments work. If you can't find each proper citation for each and every limitation, and it happens, don't argue. I should say the opposite. If there isn't one, argue it, but if there is a rejection, then I don't bother arguing it, and I just focus on the ones that matter. And then that way, when you get to the interview, you go right to the point, you get bullet points. Sometimes I've even, depending on the examiner and type of art, and depending on how egregious or not it is for my client, I've actually given my analysis, whatever, with each limitation in each page, or I'll just copy the pages that have this analysis. I'll give it to the examiner. And I had an examiner, for example, last week. She's calling me. She's on vacation in Maine and really didn't want to talk. She said, thanks so much for that. Thanks so much for your analysis. Great. I'm taking that analysis. I agree with you on each of these points. Good. We had a 2-minute phone call and we're good. So, that way you focus it in. I've also had examiners that have said to me, usually people just call, they talk, they're not prepared, they go all over the place, and we just sort of talk about it and whatever, and we don't get too far. Like, wow, to come with something like this is great, this is prepared on point, and the examiner, they're humans, they have a certain number of their version of billable hours, counts that they have to do to meet, and they get 1 hour for an interview, and it's very helpful. Now, if there is a proper limitation of everything, you can take the limitation of a dependent claim, you can put it in. You can add a limitation to the specification. If it's an issue over definition, you define a word differently than they're using it because they did a keyword search. If you have your definitions in the specification, now I define everything. You clearly write defined as, so there's no ambiguity that you mean what it is to be. Then you can take your definition, you can read those words right into your claims, and you're really not narrowing your claims any. I mean, I would argue for Festo issues, it's really not narrowing. I don't know if it would work, but point being that you're then getting what you wanted anyway, but the examiner feels that you've given in by amending the claims. And keep your high level and load of notes in order. And then you go to the examiner interview, which I'm going to skip this because I don't have too much time, and it's being discussed tomorrow with the panel. But we'll do this very quickly. Etiquette and good manners are critical. Talk about their dropping off the kids in the morning, that type of thing. They're humans. As analytical as this is, the fact is it's really very opinionated when it comes to whether this is obvious or not. In my view, it's 98% opinion whether it's obvious or not, and it's arguable. It depends, which examiner you get. Are you nice to them and so forth? In-person interviews are best, followed by, I should put video conference here, then telephone. Doing no interview, I think, is a mistake. I think everyone should do interviews all the time to talk to the person, explain to them how it is. You can explain much better than you can on paper in many, if not most cases. Well, that's about the same. I don't know, many or most is a 112 issue. I'm not sure. But anyway, let's move on. Writing a response to the office action. So now when you get to the response, all the work is done for you. My major time is on preparation. The response is basically putting it into the proper form now. Now that I've systematically done each limitation and each argument, I know what I'm going to argue. Now I just put it together. Cover sheet, amendments, arguments, declarations. I got 4 minutes. So, heading block. This is what it looks like. You'll have my PowerPoint presentation. State what it is. State what page each thing starts on. And you get into interview summary. I thank examiner Sotomayor for the telephone interview. Extra effort, whatever. Make this truthful, make it honest. I've heard from examiners, they like this. Even if you're flattering a person, tends to help. People can't help but feel positive and react to it. Thank them for their time and so forth. Be cordial, be polite. I found if you try and crack jokes on examiner interviews, doesn't work. Don't bother. They don't have senses of humor. But depends on the examiner again. But by and large, the claims made and so forth be considered, and then use status identifiers as currently amended. So claim 18, I'll say wherein I'll amend it, and you underline where it said means for measuring composition of a heterogeneous material further comprises means for measuring and so forth. So that's how you amend your claims. You say original, currently amended, withdrawn, or canceled. I'm focusing in this talk more on the substance of how to respond than I am on the structure, but underline a new strike through. So this is all basic patent law stuff. State what the office action said succinctly. You start with the paragraph. Claims 11 through 14 rejected under 35 U.S.C. 102B is being anticipated. Arguments are provided to overcome the rejection. So that way they get a roadmap. So you provide a roadmap. What are you doing? What's going on here? So they have structure of your response. You mentioned arguing, amending. And then you have your paragraphs. These paragraphs you've written before, because now you have a paragraph in your invention, a paragraph in each prior art reference. So I can say claims, now I focus it down, specifically this. He only examined 11 through 14, are directed towards spherical ball with internal transponder. You'll see this is the same as before. Citation, paragraph 39. This prevents the ball from getting lost, and so forth and so forth. Furthers recite as often, whatever. I'm selling it to the examiner of what it does and what's better. Prior art, the Ito reference is directed towards the balls are made of translucent rests in different colors, such as red, green, yellow, with an RFID tag. It shows an RFID, so forth. No reference has been located stating whether the ball is hollow or solid, or that the RFID, okay, I cut it off, or that the RFID, whatever, is freely movable. Reason I say this, no reference, and I don't say it's not there, it's not found, that's a potential malpractice issue. What if you're wrong? What if you misinterpreted or misunderstood it? So as lawyers, we like to be as non-committal as possible. We're maybe non-committal, or we can be non-committal. Okay, patent attorney humor, sorry. So, no reference has been located. That's not as bad. I didn't locate it as saying it's not there and it goes to litigation. It is there and you have a problem. So, then we cite the legal test if it's 102. The four corners of a single prior art document describe every element of the claimed invention is the one I use. It's Circuit Decision from 2000. 103, I'm citing KSR in this one. In terms of the obviousness type things, some examiners know it, some examiners don't know it. It's a good idea to put it there to make sure that they have in mind to use the proper standard, because if you have a new examiner that has 8 hours of training, it can be problematic. Okay, then this is basically, I've taken my LOTA, limitation, office action, text, and argument, and here it is. Limitation, claim 11 is directed towards, quote, everything in quotes, office action, quote it. The text, it fails to show it's hollow, and it's a center plane here. There's no quotes because I'm referring to a figure. But in my actual response, I like to actually copy and paste the figures or the text or whatever, and I put it in. You can see that figure, and when I say, you can't tell if that ball is freely floating around or falling to the ground. It's right there. Examiner doesn't have to flip open up other papers, take a phone call in the middle and figure it out. It's right there because, oh yeah, it's right there. Make his job easy. When I went to an immigration lawyer once, this was before I was a lawyer, and went to an immigration lawyer with someone to help them, and we had all our papers all over the place, and he said, okay, show me your birth certificate. Trying to find it somewhere. He's like, here's what you do. Get a binder that has those plastic pages, you insert documents. Here's the order that they're going to ask them for. Put it in order so it's ready because you want to make a good impression. Same thing here, you're doing it on paper. Make it very systematic, very orderly. Tell them exactly where to find it, exactly what paragraph, because if they can't find it, they forget it. Final rejection, move on. So you make it very easy. Here it is. Here's the text. You don't have to look further than this document here. I've copied the actual text. They want to look back at the patent, they probably will, but you make it easy and they can find it. And then in conclusion, please allow the claims. Early acceptance is requested as a general conclusion. And here's the eventual patent. This one issued back in 2012. Here's the ball reader. They put a page, and here are the issued claims. And that is it, and I am only about 1 minute over time. Oh. So patent attorney Joe. Okay, take questions. Okay, would anyone like to know where I grew up? Wait, what kind of questions? Oh, okay, sure. Go ahead.
The 103, when you're arguing, or when you do choose to insert case law, the time of the
So you're talking about in the response when I cite case law in there? So, okay, I'm just talking about it in the general sense. This is general boilerplate stuff for 102 and 103 rejection. There's other eventualities, which, I didn't get into details, but you might cite like the NPP on the applicant be on their lexicographer or the teachings of the prior art to show enablement, that type of thing. The teachings of the prior art are enough to understand what this word means. I had a examiner, this case, you have to appeal this case. This is one of those 1% allowance rate cases for this examiner. He totally used the wrong definition of the word limitation. And I did a pre-appeal first. I won on this, on what is the definition of limitation. And he was citing something that was clearly not. And my argument was, limitation is used 4,300 times in the NPP to mean a certain thing. How can you use another? How can you cite something else? And I've cited more specifically the specific NPP on claim definition. So that's one I think I cite. I think it's 2157. But it depends on the case. Where there's things to be cited, then yeah, cite case law. I mean, practically speaking, I did mostly prosecution, so I'm not familiar with a lot of case law. But if you have case law to cite, then I think that's a very good and very strong argument where it's on point. Okay, next question. Oh, sure. So declarations, they're used sparingly, which is why I didn't talk about it, because I'm not too clear my timing here. But the only time I've ever really used declarations is I've used them twice. I've used them in chemical cases in order to let me back up. A declaration is when the examiner says that such and such a thing is obvious or such and such a thing is recited over here, and you can get expert information to an expert to say, no, that's not the case. It's not the way it works in reality. So a real life example where I had this is in the boronization of titanium case, where the examiner, we had cited, I don't remember, 1 to 3% activator in the claim. The examiner had found a reference that were combining 3 different references, and one of the things that she said was this activator can be anything less than 10% of the total by weight mixture. So I got a declaration from the inventor that basically said, I've been running tests on this 40 hours a week, 40 hours a week, 5 days a week, that's the same thing, for the past 5 years, more or less, except for when I have to teach a class or two. And you cannot use 10% activator. It's not obvious to use this. I did years of trials and tests on this, and we put a declaration. Declaration came back rejected, said it's not good enough because we don't know what temperature you did it at. And we did another declaration to say it was 25 degrees Celsius, atmospheric conditions, then it was accepted. That sort of thing. So that's what you use a declaration for. Another case where I used it was on a 112 rejection where the examiner said it's not enabling. This is actually still a pending case, and I'm going to have to appeal this case, but I used a declaration to show things in the prior art to teach that you can, in fact, suspend a certain amount of weight from a pole and the pole won't fall over. Whatever, found some prior art stuff. So that type of thing. Okay, any other questions? Yes, back there. Okay, looks like we have a question over here.
Do you take examiners to task who improperly go final on you?
I haven't had it too often. You've had. What's happened in your experience? Really? Okay, the question is, what do you do with an examiner? Do you go give the examiner a hard time when they give you a final rejection right away or too soon? So, tell me, what's happened in your experience?
Well, they'll reject. They'll come up with new art. I haven't amended the claim, and they'll say applicant's claim amendment requires new art.
Oh yeah, that's an improper rejection.
That's what I asked.
Yeah, so maybe I should look out for that more. Maybe I've missed one or two.
I asked them to withdraw, and they often do.
Yeah, I found them withdraw on that. Sometimes it's just a matter of course. So examiners tend to be used to. So first you get an office action. Second office action is usually final. Just usually the way it works out, it's final. But in order to be final, certain conditions have to be met. You had to have amended the claims, whether you narrowed or broadened the scope, though they can claim it took new searching. And because now they can mark it final, there has to be some change. But if you just argue, if you do not amend your claims at all, and you give them a response, and that overcomes the rejection, their next response is supposed to be non-final. If it's not non-final, you call them up and get them to withdraw the finality of the rejection because it's not supposed to be final. I had a case just recently where I had it was a RCE. So after final rejection, why don't I talk about that a little? Maybe I'll talk about examiner interview a little too. We'll go back there. After final rejection, there's a few things you can do. You can file a notice of pre-appeal, and you put your arguments in 5 pages or less. The idea is because doing a full-blown appeal costs a lot of money, so you start with a pre-appeal. And you put your arguments in. It's reviewed by a panel of 4. It's reviewed by the examiner, his supervisor, usually someone from the quality control department, and one of the heads of the technology center. So the hierarchy is examiner. Above him is a supervisor. Above them, there might be another head or not, or just a head of the technology center. And then it's reviewed by this panel, and they'll review and see if it's proper or not. Usually, I think statistically, 70% of those cases are just reopened, and the examiner comes back with a new rejection. So sometimes they're allowed and so forth. The other thing you can do is file a request for continued examination if you don't want to go towards the appeal route. One sec. Request for continued examination is basically like this. You pay a fee, you get more time. You give them some money, and you get another shot at it. Now, typically, they're putting them in the back of the pile. They're not examined again for a while. Some cases I've had not. They're handled right away. So I had one of these where I filed an RCE. They went and objected to the drawings, which I didn't object to the first time when I first filed it. So I corrected the drawings, and then the examiner gave me a final rejection right away and said, "You didn't have any arguments." And I said, "Yes, I did." And basically what happened was he missed it in the file because he saw the later thing of the corrections and didn't see further. The other thing that keeps happening to me, I don't know if others have seen this, but you electronically file at the patent office. The document's there. You can see it in the file. You look at it a year later, it's missing. It's just totally not to be found. The way to deal with this is you need to call the Electronic Business Center. They're the only ones that have it, and you need to have the receipt. And on the receipt, when you do electronic filing, is an EFS ID, Electronic Filing System ID. That's the only number they will look it up with. And then and only that department can find it. And they'll say, oh, yeah, it's here. I don't know why it's not in the file. And they'll put it back in the file, and it takes them a few weeks. So I had a case where a foreign associate, and they notice it's not there. Like, what is this? You didn't file the new power of attorney in our amendments. What's going on? And I'm like, you don't remember. It's a year ago. So I looked, and I'm like, no, wait, I got the receipt here. I know what happened. This has happened me 4 times already. Usually it happens to be information disclosure statements. So I called, I did this, they put it back in the file. What I didn't realize is the examiner was re-examining it, so she examined it based on the old claims, so then she had to give me the whole explanation in writing, and I explained it in the whole thing, and then the supervisor was able to get her more time in order to re-examine with the new claims, because it really was filed a year ago or whatever. Anyway, that's just a little tangent tidbit thing. There's a question over there. Yeah, I think it's good practice, but examiners, like judges, anyone, they don't like to read too much. So you have to put the important things high up on page 1 and maybe page 2. If you put it on page 8, forget it, they're not going to see it. Right. Okay, any other questions, or I'll go to examiner. Oh, yes, sir, go ahead. And then back there. No, hold on, I'm sorry, him first, and then I'll.
What's your process? Would you change anything if examiner cites 5, 6 references?
I handle it the same way. So the question is, examiner cites 5, 6 references. I think my maximum is 8. When they cite that many references, how do you handle it? It's the same thing. Each limit.
There's a problem.
Oh.
The focus section is only an agent.
Well, then, I mean, practically speaking, those are, of course, annoying. When the office action doesn't tell you why he's citing it, but you do the best you can. You try and prepare each limitation, and then you have to look in the prior art and understand the prior art for yourself. And once it's that many references, you're not going to read and understand like 8 references. But at that point, you figure out what are the major references they're citing, and just look at least the lines or paragraph that are being cited in there, because sometimes it's being cited to show a processor, and it's a throwaway thing anyway that you didn't, you put in clean because you had to, or whatever it is. But then you focus on the important limitations, and you see, are there actual references? And you have to do more searching and digging, because the examiner hasn't done his job. But at the end of the day, he works for the government. You're private, paid by a client. So one of you has to do quality work, and it's not the government worker. So that's just the nature of it. And then you have an examiner interview to discuss. I haven't seen that lately. I mean, I've seen mostly more filled out office actions. I mean, I think quality is better than it was a few years ago. I deal with 3612 is a curse word for me, so yes, I do. Okay, fair enough. Yes, that's where you'll see it. Whatever. Maybe I shouldn't go on recorded record saying how much I hate that art unit. But, all right. Anyway, any case, and the back there, yes. Yes, I totally did in 3612. Yes, I have. Yeah, I had an examiner like that. I called the ombudsman's office, and I actually told him, and he had no idea such a thing existed. So the ombudsman's office is actually only to help you with flow and process. They won't talk about substantive things. If it's substantively really bad rejection, they won't do anything. I called them, but that Heart 5B, when the neutral wire was cited, the thing. That was the first time I tried the ombudsman's office. All they could do was hawk the examiner until he agreed to an interview, because he was supposed to agree to an interview and wasn't returning phone calls. Different problem. I mean, hopefully the guy's not either, rather than not being there, I hope he's doing better work. I hope he's doing good work now. That would be preferable. But yeah, and then recently I brought up this that to the ombudsman,